Good morning, good afternoon, or good evening, and welcome to the CIL podcast. My name is Arron Honniball, and I'm a research fellow in the Ocean Law and Policy team at the Centre for International Law. Today we shall be discussing the model agreement for the provision of facilities for the International Tribunal for the Law of the Sea, which was signed between Singapore and the Tribunal in June of 2020. As this agreement, in essence, strengthens the possibility that the Tribunal may exercise its functions in Singapore, in addition to at its headquarters in Germany, this agreement is a win-win for both parties and the wider international community. As the agreement has a rather long and dry title, I'm going to simply refer to it as the Model Agreement, and likewise I will refer to the International Tribunal of the Law of the Sea as simply Int'l. We shall also be focusing on the Model Agreement's possible utilisation in regional-centred proceedings, i.e. of an Asia-Pacific persuasion. It is worth first highlighting that this podcast is an accompaniment to an article published by Valentin and I in the December 2020 issue of the Asia-Pacific Journal of Ocean Law and Policy. I would respectfully urge anyone who has not yet had a chance to read that short piece to hit the pause button, take a look, and then return to this podcast for a few further insights and conclusions that build upon that article. If anyone has difficulties in gaining access to the published article, please reach out to me via email and I shall happily provide a copy for personal use. So in this podcast, we will begin with a brief introduction to the Law of the Sea framework to which Int'l is found, followed by a look at Singapore's strategy to position itself as a centre for international dispute settlement across the spectrum of public and private international law. Both developments will help contextualise the Model Agreement. We will then have a brief recap of the Model Agreement's objectives and its contents, but this issue is more extensively covered in the aforementioned article. Finally, this podcast will focus on the contemporary opportunities to operationalise the Model Agreement to further the peaceful settlement of regional disputes or uncertainties in the law of the sea. So first let's put the Model Agreement and Int'l within their wider international law context. We shall return to advisory proceedings later, but as a general rule of international dispute settlement, disputes arising from the interpretation or application of international law, including UNCLOS, shall be settled through any peaceful means of the parties' choosing. Section 1 of Part 15 of UNCLOS builds on this general approach. What is rather special for UNCLOS is that when this has not led to the settlement of a dispute concerning its interpretation or application, UNCLOS provides for compulsory procedures entailing binding decisions. These procedures are subject to certain limitations and exceptions regarding jurisdiction rationale materiae, laid down in Section 3 of Part 15 of UNCLOS, some of which exceptionally allow for compulsory conciliation procedures in accordance with Annex 5. Finally, it's important to note that parties have a choice of 4 procedures for settling UNCLOS disputes. First, of course, there is Int'l constituted under Annex 6, which is the subject of this Model Agreement, but there is also the arbitral tribunals under Annex 7, with the Arctic Sunrise Tribunal pictured in this slide. There's the International Court of Justice, and finally there's special arbitration under Annex 8 for certain categories of dispute which has not been used to date. Now, in terms of the Singaporean context of the Model Agreement, it is clear that Singaporean practice, both within law of the sea and other fields of international law, is part of a broader Singaporean policy to be a leading neutral venue for peaceful dispute resolution. Within a law of the sea context, this includes being selected as a suitable venue for numerous rounds of compulsory conciliation in the first ever case brought under Annex 5 of UNCLOS, the Timor Sea Conciliation. It also includes a 2017 host country agreement with the Permanent Court of Arbitration, which is interesting because the PCA has been appointed the registry to all arbitral tribunals constituted under Annex 7 of UNCLOS, with the exception of the Southern Bluefin Tuna case. Finally, to go beyond the article, is noteworthy that Singapore has exercised its rights to nominate arbitrators and conciliators under the UNCLOS framework. Indeed, despite global nominations being surprisingly low, Southeast Asia has a strong track record, with Indonesia, Thailand and Vietnam also exercising their nomination rights. So the origin, purpose and content of the Model Agreement is delved into significant detail in the publication, including in comparison to the previous practice from Germany, where Int'l has its permanent headquarters. and at the time of this recording has held all of its hearings to date. I'm not going to repeat that here, but simply highlight that the agreement essentially exists to provide Int'l with the diplomatic privileges, immunities and facilities necessary to exercise its functions in Singapore, while safeguarding its independence. The model agreement is the result of consultations that first began in 2007, and at the time of recording, we are awaiting if and when it will be operationalized. So let's go beyond the text and its history and ask ourselves what actual role Int'l could currently play in dispute settlement in the Asia-Pacific region, and in respect of which types of dispute. If we think back to the introductory remarks on Int'l and its role within the UNCLOS regime, we already see a few limitations on the functioning of Int'l in an Asia-Pacific dispute. First, absent any special agreement, this excludes recourse to Part 15 in disputes involving a non-contracting party to UNCLOS, which would currently exclude disputes involving the USA, Cambodia, Bhutan, and North Korea. Second, on exceptions, Australia, China, Malaysia, Palau, the Republic of Korea, Russia, Singapore, and Thailand have, to varying degrees, excluded disputes under Article 298 of UNCLOS from the compulsory dispute settlement procedure, which would exclude recourse to Int'l and any Singaporean hosting thereof. Thirdly, on choice of procedure, unless both parties to a dispute select Int'l or agree otherwise, arbitration under Annex 7 and not Int'l is the default procedure for most categories of dispute. Within the Asia-Pacific, only Australia, Fiji and Timor-Leste have chosen Int'l, with Myanmar and Bangladesh only choosing Int'l for the purposes of the Bay of Bengal case. Similarly, choice of Int'l is limited under the UN Fish Stocks Agreement, where compulsory dispute settlement before Int'l for the Asia-Pacific would currently only include a hypothetical dispute between Australia and Fiji. Asia-Pacific disputes concerning other instruments with a compromissory clause are similarly limited in utilizing Int'l, either by lacking a relevant choice of Int'l under the instrument or by cross-referencing the limited choice of Int'l under UNCLOS or the Fish Stocks Agreement. In short, the result is that to date, Int'l has not heard contentious proceedings between Asia-Pacific nations on the merits. Nonetheless, Int'l plays a unique and key role in UNCLOS dispute settlement, which could broaden the employment of the model agreement. Firstly, Int'l is the default forum for prompt release proceedings. Regional institutions of Int'l adjudication on prompt release includes the Volga case, Hoshimaru, and Tumimaru case. Secondly, the Seabed Dispute Chamber of Int'l has exclusive jurisdiction for disputes concerning Part 11 of UNCLOS and may render advisory opinions on such matters. Thirdly, Int'l is competent in provisional measures proceedings pending the constitution of arbitral tribunals. If states fail to reach agreement on which court or tribunal to submit provisional measure proceedings to, Int'l will have exclusive jurisdiction. Notable Asia-Pacific provisional measures proceedings before Int'l have included the Southern Bluefin Tuna case, the Land Reclamation case, and the Enrique Lexi case. In all of the cases above, proceedings before Int'l with an Asia-Pacific focus may benefit from being held in Singapore. Incidentally, the President of Int'l may also make the necessary appointments for arbitral tribunals if parties to a dispute cannot agree on its constitution. This has been necessary in all Annex 7 arbitrations involving an Asia-Pacific state to date, and can bring a dispute closer to the tribunal. This is evident in the Bay of Bengal case, which was transferred to Int'l shortly thereafter. It may therefore be more opportunities arise for the use of Int'l than the current choice of states demonstrate. Our discussion so far has focused on contentious proceedings. However, it is important to note that Int'l also has advisory jurisdiction, and here I would envisage a much greater role for the model agreement in the future if the parties so desire. The Seabed Dispute Chamber has jurisdiction to issue advisory opinions. In 2010, the International Seabed Authority requested an advisory opinion from the Seabed Disputes Chamber, to which numerous Asia-Pacific states contributed during the written proceedings and the oral proceedings. Respectively, this included Nauru, South Korea, Russia, China, Australia and the Philippines, and in the oral proceedings, Fiji, Nauru and Russia. An Asia-Pacific-centered request could benefit from regional proceedings. Int'l also considered itself competent to render full bench advisory opinions on law of the sea matters, provided that an agreement related to the purposes of UNCLOS provides for such competence. While the SRFC advisory opinion is the only practice to date, regional participation included written submissions by New Zealand, China, Micronesia, Australia, Japan, Thailand, Sri Lanka, the USA and the Foreign Fisheries Agency, and oral submissions by Australia, Micronesia, New Zealand and Thailand. To conclude, the model agreement is a welcome progression towards increasing the accessibility and perceived impartiality of the tribunal, and a further arrow in the quiver of Singapore as a global hub for peaceful dispute resolution. Moving forward, as Judge Paik suggested, a network of model agreements may be beneficial to further expand the tribunal's accessibility, starting not least with Argentina, which has already signalled its willingness to have Int'l sit in Buenos Aires. Additionally, or even alternatively, COVID-19 has necessitated the amendment of the tribunal's rules of procedure to allow for meetings, hearings or readings with remote participation and/or public access in exceptional cases. The 2020 hearings in the delimitation case concerning Mauritius and the Maldives has already involved remote participation, and embracing such technology as a more general option for the parties may make the tribunal more attractive as a choice of procedure, with the added benefit of potentially reducing the environmental impact of dispute resolution proceedings. And that concludes this short presentation. Thank you for listening.